And a very good morning to you. It's John Fradgley from the Bell Legal Group, back with you for another program of The Law and You, which means it must be Tuesday morning. It's your opportunity to get free legal advice between now and 9:30. That's 10:30 Tweed Coast time. All you need to do is ring that telephone number. 55208888 is the number. That number again, 55208888. If you're south of the Tweed River, don't forget to put 07 in front of the number. Or you can email us at talkback@4crb.com. And if you do, we will deal with your question next week, because we can't take the emails and deal with them at the same time while we're on air. But we have someone who's been very patiently waiting there this morning as we say good morning to our first caller. Paina, how are you today?
I'm good, thank you, John. It's Karina.
Sorry, how do you pronounce it?
Karina.
Parina. Oh, sorry, I think they may have misspelt it on our board, but that's okay. How are you today?
Yeah, I'm pretty good, thanks, John. How are you?
Well, thanks. How can we help?
I just give you a quick summary. I own two properties down in Lyndhurst in New South Wales, and I got really unwell with my job, and me and my husband were selling the properties, and we were going to move up here to Queensland. Anyway, and I got really unwell, and I came up a little early, and he was supposed to follow me up.
Right.
And a few months passed, and he decided he didn't want to come anymore and be in the marriage. And
right.
He stayed in my house.
Right.
Now, two properties are in my name. And my question is, how can I get him out of my house? He's absolutely trashed it, and it's unsaleable. And where can I get help? Because nobody can help me because I own the property.
Right, okay. Well, I mean, obviously the first thing you need to do is to get your husband out of the property that he's in. Is he still in it?
Yes, he won't leave.
Okay, so you're going to need to, unfortunately, you're going to have to go through the process of getting an order, a court order for him to leave. Have you sought any legal advice on this as yet?
I've asked a few people, and they told me that I don't have any rights.
Well, no, that's not right at all. So you certainly do have rights. What part of the Gold Coast do you live, Parina? Which area?
I'm in Varsity.
Varsity. Okay. Well, look, this Thursday evening, if you're looking for some preliminary advice on a free basis, you could go along to the Robina Community Legal Centre. I think they have actually changed their name. What do they call themselves now? My Community Legal, formerly the Robina Community Legal Centre. Now, they operate out of the Gold Coast City Council's Robina Community Centre, which is at 196 Robina Town Centre Drive. Do you know the Robina Town Centre at all?
Yeah, this isn't a community centre near the library?
Yes, it is. So right. In that building, every Thursday evening from 6:30 until 8:30 on a Thursday, there are a number of lawyers in attendance. No need to make an appointment. They don't take appointments. You just simply rock up. And if you get there early, you would certainly be able to get to see a lawyer who would be able to give you initially some advice about the direction you should be taking in relation to this matter, and then hopefully they would be able to recommend you to a law firm that may be able to assist you with the matter. In terms of the action that you would need to take, whether that action will be under the New South Wales residential tenancy law, because your husband would unfortunately be regarded as a tenant in the property, possibly a tenant at will, you still have to go through the process of evicting him. So you need to get a court order, and then if he still refuses to go, then a warrant. The alternative is that if he claims that he needs to stay there and is is initiating action for property settlement and claiming property from you, then the process might be a little bit more difficult. But it does, in those circumstances, it would come under the Family Law Act. So there are a couple of alternatives there that you need to look at. But I would certainly be speaking to someone there initially on Thursday evening to get some advice, and they'll be able to head you in the right direction.
Okay. John, also, does it make any difference that I owned the two properties before we got married?
Well, yes, it does to a certain extent. Unfortunately, when you married, they became what's referred to as matrimonial property. So if you didn't have a financial agreement, a binding financial agreement with your husband prior to your marriage, or you didn't subsequently enter into one, which basically said what would happen to your assets in the event of a split, then those properties are regarded as assets. However, if he's an able-bodied male, how long were you married for?
Nearly 8 years.
Okay. So if he's an able-bodied male and there's no reason why he can't work, the court will certainly take notice of the fact that you brought those properties into the marriage, and hopefully that will mean that you will get the lion's share of those two properties, if not all of the properties. But it depends on a lot of factors that need to be taken into account, and it's really a specialist family law area. So I would suggest that you raise that again when you go into the My Community Legal Centre on Thursday evening. All right then?
Thank you very much, John.
Okay, Perina, all the very best with that.
Okay, thank you.
Cheers now. And on 4CRB, it's just coming up to 12 and a half minutes past 9. That's, of course, past 10 down on the tweet. As we say, a very good morning to Roland. G'day, Roland. How are you today?
I'm very, very well. Thank you very much. How are you?
Well, indeed. How can I help you?
I'm actually separating from my wife, and we've come to an agreeable property settlement.
Mm-hmm.
What I'd like to know is how can I register that document with the courts?
Right, okay. Well, what you need to do is actually enter into a property settlement agreement. So one of you will need to consult a lawyer to get that document drawn up, and then the other of you will need to be independently advised on the document, and then you need to have that document approved by the family court. So, and that's the only way that you can end up with a legally binding agreement. So that would be my recommendation. You should. Do you have a lawyer, family lawyer, who's working for you at present?
No, not really.
Okay, right.
No, we've come to this agreement on our own. Like we've drawn it up ourselves, and we're getting it signed in front of a witness and all that sort of stuff.
Well, unfortunately, that won't be binding.
Okay.
So unless it is actually sanctioned by the family court or by the Federal Circuit Court, the agreement will not be binding. So you really do need, unfortunately, to get that dealt with properly, unless you're prepared to trust your spouse that they'll not do the wrong thing, because that agreement could be overturned for up to 1 year after the date on which you actually get a divorce.
Oh, okay. All right then.
So, Roland, the only other thing you could do, which part of the Gold Coast do you live?
I'm down near Jake as well.
Okay, so you're up the northern end of the coast. The only other thing that I could suggest you do would be to ring the Gold Coast Community Legal Centre and Advice Bureau. They do have... they do visit centres up that end of the coast. You could ring them and find out when they're next up there, and you could go in and see someone there in the hope that they could provide you with further advice. But they certainly will not do the agreement for you. You will need to have a lawyer do that. And the agreement must have attached to it details of all of your assets and liabilities, and also details of all of your spouse's assets and liabilities. And there need to be certificates by the two separate lawyers saying that one advised you in relation to the terms of the agreement, another that the other lawyer, who's independent of your lawyer, has advised your wife in relation to the terms of the agreement before it can be taken to the court to be sanctioned.
Oh, okay. All right then.
Do you want that number for Gold Coast Community Legal Centre?
Yes. I'll just grab your pen quick.
Okay.
Radio.
So their telephone number is 5532
5532
9611.
9611.
Yes.
All right, thank you very, very much for that.
Okay, no trouble. All the very best, Roland.
Thanks.
And the time on 4CRB is just coming up to 16 minutes past 9. That's, of course, past 10 on the Tweed. We'll be back after this word from our sponsor.
There are two things certain in a Gold Coast summer: regular afternoon storms and the high risk of skin cancer under the Gold Coast sun. A regular skin check can save your life. Now is the time for a full skin check. Book an appointment with one of Skin Alert's advanced trained female or male skin doctors. Call our sponsor, Skin Alert Paradise Point, on 5577 5533. Act now.
Hey Mum, pop quiz. What's BYOD stand for?
It's bring your own device. And thanks to Harvey Norman, I know all about it.
Really?
Really. I've already been in to see the lovely staff there.
What'd you get? I don't want something different.
Don't worry, Harvey Norman knows what your school requires, and they've got on-site technicians and included phone support for when you muck it up.
Mum.
Getting back to school is easy with Harvey Norman. Tablets, notebooks, software, printers. Harvey Norman, your BYOD specialists. Get ready for BYOD in store today.
Our sponsor.
And this is Law and You on 4CRB. Our telephone number 55208888. That number again 55208888. We presently have no callers online, so if you would like an answer to a query you have, give us a call right now. But you'll have to be quick because the program, of course, finishes at 9:30. So that's 55208888. I'm pleased that we have had a little bit of a break though, because there were a few things that I wanted to talk about this morning. One, of course, is the changes that have come in to law in Queensland in relation to the use of telephones whilst you're driving a car. You'd have to have been on holiday on Mars or alternatively living under a rock not to have noticed that there are significant changes that have been made not only in Queensland but of course also in New South Wales in relation to these laws, and Queensland is also following New South Wales with the introduction or the trialling of phone cameras which will spot people on their telephones. At the moment, the trial down in New South Wales, I think from memory, is issuing warnings to people who are caught by those cameras. But I think it's from the beginning of March that those warnings will no longer be warnings, they'll be fines. But that, of course, does not mean that if you get passed by a police car and they see you on your phone, that they will not pull you over and book you. And the fines now are incredibly high. Queensland, for example, $1,000 is the fine that came in from the 1st of February. So you would certainly be very foolish to still consider doing that. But enough of that. We've got a couple of callers online. We'll deal with those. As we say, a very good morning to Malcolm. G'day, Malcolm. How are you today?
Yeah, not too bad, thanks, John.
How can we help?
John, last year my mum, she changed her will.
Mm-hmm.
And there's a copy of it in a law firm.
Mm-hmm.
In there, okay. And I've got a copy of it too. I've got still got the original.
Mm-hmm.
My question to you is, should my other siblings be notified of this change of will?
Well, that's entirely up to your mother. Because the document
she's no longer with capacity.
Oh, okay. So she no longer has capacity. And
That's correct.
Are you her power of attorney?
Well, yes, I am, but only on finance at the moment. But it's about to be determined as to whether or not I'm going to remain power of attorney as a result of a hearing only recently.
Right, okay. Well, look, there's no legal obligation to provide a copy of the will to anyone prior to your mother's passing. Of course,
Right.
Once your mother passes away, any beneficiary under the will or any beneficiary under a previous will is entitled to see a copy of that will and any previous wills that they featured in. So that's the strict legal position. I suppose it's a question of A, how you get on with your siblings, and B, whether providing a copy of the will to them is going to cause more problems than it solves. Is it that they have asked for copies? Have they been asking for copies?
No, because they're unaware of the change.
Okay, well, if that's the situation, then no, I would say that you should not provide a copy of the will to them.
Yeah, very good. Thanks very much for that.
Okay, then, all the very best, Malcolm. Cheers now.
Thanks, John. Bye.
And the time on 4CRB quickly approaching 21 minutes past 9. That's, of course, past 10 on the Tweed. As we say, a very good morning to Barbara. G'day, Barbara. How are you today?
Very well, thank you.
That's good. How can we help?
I wanted to find out, I have some money and I want to give a loan to my daughter.
Mm-hmm.
I want to give an interest-free loan, which will be taken out of when my husband and I go.
Mm-hmm. That'll be taken out of her share.
Taken out of her share of their inheritance.
Right.
To be repaid there.
Okay, so...
Do I have to... Can I write out an agreement that you both sign, or do I have to go through a lawyer?
Well, Barbara, it's certainly advisable that the document is drawn up properly to reflect the loan. You need to bear in mind that if there's no requirement for repayments and no requirement for the payment of interest, that the loan will become what's called statute barred after 6 years. So if the loan is intended to be longer than the period of 6 years, you would need to build into the document a provision for repayment, or alternatively put a longer repayment period in the loan. So my recommendation would be that you do get the document drawn up by a solicitor. It's only a fairly simple document, so the cost will not be significant.
Yeah.
The other thing, of course, that you should do too is probably make reference to that loan in your will to provide that if your daughter still owes you all or part of those funds at the time of the passing of the survivor out of you and your husband, then that amount is to be deducted from any entitlement that she may receive under your will, so that in the unfortunate or in the unlikely circumstances that the loan agreement was mislaid and no one knew about it, the reference in the will would clearly bring that to light and ensure that the adjustment is made.
Okay, and also I want to do it for my son who lives in Canada.
Mm-hmm. Well, you can do exactly the same for him. There's no reason why you can't do that. And in fact, if you were to do it for the two of them, that, of course, would significantly reduce the cost, because the one agreement that you do for your daughter could simply be copied or just slightly changed for your son, so you'd basically get more bang for your buck in making the changes to your will and also drawing up the loan agreements, because the cost of doing the second set of documents would be significantly reduced, and the change to your will noting your daughter having received that benefit, that same provision could be put in about your son in the will as well, and so that would mean that there'd only be one change required to your wills.
Oh, I want to redraw my whole will.
Oh, right, okay. Well, if that's the case, then you're going to cover that off anyway. But the important thing is just to make sure that that loan agreement is done correctly, depending on what length of time you think it may run for.
Well, as long as I live.
Yes, okay. Well, if that's the case, then I would certainly be getting a lawyer to draw it.
And if like my son is in Canada and he won't be here to sign the papers.
No, it can be sent over to him to be signed. In fact, it could be emailed to him. He could print a copy of it over there and email it back.
So that because would be agreeable.
Yeah, because the agreement could be drawn with a provision in it saying the parties agree that this agreement may be signed by counterparts, so that means your son signing one copy in Canada, you signing a copy here, and it can also contain a provision which says the parties agree that the exchange of documents electronically is accepted as being legally binding. So you could cover off all of those things.
A reputable lawyer
can
do all this for me?
Right. Well, what I would suggest, are you in Queensland or New South Wales?
Queensland.
Okay, what I would suggest you do then is ring the Queensland Law Society. Have you got a pen handy? I can give you their number.
Yes, I have.
Okay, so the number for the, where are we, Queensland Law Society? back one page. Yes, so their number is 1300 367 757. Yeah, so if you just ring them and tell them you were talking to me on the radio and that I suggested they call you. And then depending on where you live on the Gold Coast, they should be able to make a recommendation to a lawyer who can do this for you who's convenient. You can also, of course, ring up and get an estimate on pricing before you actually make an appointment to go in as well.
Okay, thank you very much.
Okay, Barbara.
Thank you very, very much.
All the very best. Time on 4CRB has just passed 26 minutes past 9. Of course, that's 26 minutes past 10. We'll be back after this word from our sponsor.
There are two things certain in a Gold Coast summer: regular afternoon storms and the high risk of skin cancer. Book a skin check at our sponsor Skin Alert Paradise Point on 5577 5533.
And this is the Law and You on 4CRB. We only have 3.5 minutes to go, so if you have a very quick query, you're more than welcome to give us a call right now on 55208888. While we're waiting, a couple of other things that I wanted to speak about was the change to laws in relation to credit files, which come in on the 14th of February. And I think this is a very significant change because credit score providers or credit score companies will no longer record the filing of civil proceedings against someone. They will only file if there has actually been a judgment against someone. Now, to me, this is quite a good change because from time to time, vexatious litigants might issue proceedings against someone in circumstances where they have no basis for their claim, simply to have a black mark put against the file of the person who's trying to seek finance or from a bank or something else. And this will mean that not only will they no longer be able to record civil proceedings on your CRA file, but it will also mean that if you did previously have one of these notations on your file about proceedings that have been issued but which are clearly vexatious, you're able to ring the credit, or you're able to get in contact with the credit reporting agency and have that entry removed from your credit file. So that'll be a great change to the law, and I hope that will be of assistance. We have one final caller. We'll try and deal with it quickly. Good morning, Peter. How are you today? Peter, are you there?
Yes.
How can we help?
Yes, good morning, John. It's with regards to a tenancy. Had people just pop round keys in an envelope. No outstanding rent, nothing like that. And they're gone, no forwarding address, anything like that. What possibility do I have of recovering 3 months' rent, which is about $6,600?
So they basically just put the keys in the letterbox and they've taken off, is that right?
Yes.
Okay, well, look, the first thing, of course, you're going to have to do is find them. And so you know, there are various things that you might be able to do there. Obviously, electoral name search, those sorts of things. Facebook is always a good one. Instagram, all those things. So you can, and in fact, where people won't give you an address, I have seen cases where the court has approved the service of proceedings on Facebook. So there are a number of avenues available to you, Peter, but the first one is going to be to try and locate them and find out where they are, or find some means of communication.
Yeah, and then with civil law?
Yes, unfortunately you'll have to bring proceedings through QCAT. Are you in Queensland?
Yes, I am.
Yeah, so the Queensland Civil and Administrative Tribunal will be the weapon of choice. All right then.
Thank you very much.
Okay then, Peter. All the very best.
When you're in this situation.
No, that's for sure. I'm glad to be of help.
Thank you, John.
And that just about brings us to the 9:30 news. This is John Fradgley from the Bell Legal Group. It's been great to have your company today. I look forward to being back with you again next Tuesday for more of the Law and You. But until then, it's goodbye and God bless.